Brother Bishops, I now call to the podium Archbishop Jerome Listecki, Chairman of the Committee on Canonical Affairs and Church Governance, to introduce a presentation on Pope Francis' revision to Book 6 of the Code of Canon Law, Penal Sanctions in the Church. As you know, the Holy Father's revised law will go into effect on December the 8th. With that in mind, the Committee on Canonical Affairs and Church Governance has for time on our agenda to provide a brief overview of the legislative changes. We're very pleased that Archbishop Charles Scicluna of Malta accepted an invitation to speak with us on the topic. Because of ongoing international travel restrictions, however, the Archbishop is unable to be with us in person. He graciously agreed to pre-record his remarks so we can still benefit from his proven expertise and extensive experience in this area. Archbishop Listecki, is there anything you wish to add before the presentation?
Thank you, Archbishop Gomez. Tend the flock of God that is in your charge, not by constraint, but willingly as God would have you. Those are the opening words Pope Francis chose to promulgate his recent revision to Book 6 of the Code of Canon Law on penal sanctions in the Church. Tend the flock of God that is in your charge. It is the Holy Father's hope that the new revisions in the Code of Canon Law will assist bishops and other superiors in applying the penal law of the Church more effectively as an ordinary part of their pastoral governance and as a pastoral instrument to foster the salvation of souls. After the new norms were promulgated, the Committee on Canonical Affairs and Church Governance received several inquiries from bishops asking if the committee intended to offer any guidance for bishops on this new code. Because the law goes into effect on December 8th, it seemed appropriate that at this meeting we would spend some time introducing the new law. We were truly humbled that Archbishop Charles Scicluna of Malta agreed to take time out of the demanding schedule that he has to assist us with this process. And he deeply regrets being unable to be here in person, but he recorded his insights in two parts. We'll watch the first part today, and then watch the second part tomorrow. That's to accommodate the needs to readjust our agenda and the schedule for us to meet. I hope that you will open your minds to learn from this formidable expert on the topic, a very clear presenter and someone who genuinely speaks to us as a brother bishop. You received in your packet at registration the canons of Book 6 of the Code of Canon Law. It will help if you have them before you. Now, on December 1st, from 11 a.m. to noon Eastern Time, Archbishop Scicluna will join us for a dialogue and question and answer period on Zoom. So, as you watch his presentation today, reflect on the norms, please jot down your questions, and you can give them either to me, to any of the members of the Canon Law Committee, or to staff. Finally, be a little three parts. Next year, we hope to offer a workshop for bishops that will provide insights into the practical application of the Church's penal law in a diocese. And I'd like to offer another insight and offer Bishop Barczak to come up and inform you of another opportunity.
Actually, there's two opportunities that will be upcoming. The School of Canon Law from the Catholic University of America is preparing a workshop, and if you want to mark the dates, May 16th through the 18th, 2022 in Cleveland, Ohio, there will be a joint meeting of the Eastern region of Canonists and the Midwestern region of Canonists, and they've asked me to be the main presenter for that workshop. I know Archbishop Scicluna personally is a longtime friend, and you're going to get a mouthful of information, and on a practical level, I think it would be a great thing for you to send your canonist, at least one canonist for your diocese, to one of these other workshops.
Archbishop Gomez, our Holy Father has given us a great opportunity with this new legislation that I know will help us in governance of our diocese. But it will only be effective if it is actually implemented. So I hope all enjoy the presentation.
Thank you, Archbishop.
It is a pleasure and a privilege for me to address you, dear bishops of the United States of America, from the island of Malta. COVID restrictions made it very difficult for me to be present physically with you today. I was asked, and I have been invited, to offer a short introduction to the revision of Book 6 of the Code of Canon Law. As you know, Book 6 deals with sanctions in the church, or penal sanctions in the church. And the point of reference for us is the Apostolic Constitution by Pope Francis from 23rd May 2021. The name of this constitution is Pascite Gregem Dei, shepherd the flock of the Lord. In fact, the Pope starts with a reference to the ministry of bishops, but immediately goes to the root of our system of discipline and system of laws. He says that faith is reflected in these norms, and faith is the source of the binding nature. I would like to add a comment here that this is one of the more important aspects that underpins our system, but it is also a limitation in the sense that we are dealing with norms, with laws that imply, presuppose submission which comes from faith. It is a voluntary submission. So we've had cases where people walk away from the church because they do not like the laws of the church. And we've also had cases where priests who have been accused of very serious crimes walk away from the church to evade and avoid the discipline of the church. So this is a very important point. I think we need to be very realistic when you approach canon law. It is a system that lacks physical coercion, and I think that's very good news, but it's based on the spiritual submission of the faithful to the law, and this is an expression of their faith. Faith, according to Pope Francis, is the reason why the norms show the Church's maternal mercy, since the Church knows that its ultimate goal is the salvation of souls. And the Pope mentions that this review and the revision of Book 6 is an expression of our very special moment in history, what the Pope calls a change of epoch rather than an epoch of changes. The main purpose of this revision is to offer shepherds, our bishops and people in authority in the church, an adequate salutary tool suitable for correction that can be used without delay, tempestive, the Pope uses this adverb, tempestive, without delay, and with pastoral charity. Why? To avoid more grave harm and to deal with the wounds that derive from human weakness. You notice that the Pope's approach is very pastoral, and he is trying to instill in us this confidence that when we apply penal sanctions, we're actually doing our job. We're being also very pastoral and also expressing the maternal charity of the Church. The Pope gives a very, very quick review of the history of this reform that was initiated by his predecessor, the Emeritus Pope Benedict XVI, in 2008. It took a number of years for the Pontifical Council for Legislative Text to come up with this new proposal that was approved by the Pope this year and is going to enter into force on the 8th of December 2021. There were limitations in the Code of canon law from 1983, and the solutions offered, according to what Pope Francis says in his Apostolic Constitution, try to be possible, clear, and simple. Why such a reform, and why do we need penal sanctions or penal discipline in the Church? And the Pope says that penal discipline binds the whole people of God under the guidance of the shepherds and superiors of the local communities. This obligation to follow penal laws is intrinsically linked, the Pope says, se iungi numquam potest, to the pastoral duty or office, and constitutes a concrete application or corollary of charity. Charity towards the Church, charity towards the Christian community, towards the victims of crime, and charity towards the perpetrators who need the mercy and the correction of the Church. The failure to understand the intimate relation between the exercise of charity and the use of penal discipline when necessary has in the past produced a lot of bad consequences. The Pope uses the term multa mala. And this failure helped consolidate lifestyles and life choices contrary to canonical discipline that cannot be remedied by exhortation and persuasion alone. With time, these lifestyles become ingrained and cause scandal and disseminate confusion among the faithful. So the Pope is exhorting us, Bishop, and people and authorities in the Church to do what needs to be done when confronted with difficult situations, and not forget that the use of penal sanctions is an integral part of pastoral charity. The recourse to penalties, therefore, is necessary, and the Pope has some very strong words. He says that a bishop who neglects use of the penal discipline is not fulfilling his office faithfully and diligently. We remember immediately the very strong words used by Pope Francis in his motu proprio, come una madre amorevola, as a loving mother, which calls us, Bishop, to task, and also helps and empowers people to report bishops who are negligent in doing their job and fulfilling their mission. Pastoral charity, therefore, requires shepherds to have recourse to the penal system whenever this is necessary, with due regard to the three purposes that render this system indispensable in the ecclesial community. And the Pope actually gives the three purposes that we will find also listed in the revised version of the Code. We had a reference to them in the old version of Canon 1341. Now we find that these three purposes are included at 3 points in the revised Book 6. And these three purposes are that the demands of justice are satisfied, that the perpetrator is reformed, that scandals are repaired. And one immediately realizes that the purpose of penal sanctions in canon law are not the same as penal sanctions in a civil law context. The purpose of penal law in the Church is mainly spiritual, but it has also to meet the demands of justice. Another point made by Pope Francis, which I think is very, very important, is the nature and the attributes of a penal or canonical sanction. In fact, he says that the canonical sanction also has the function of reparation and of a salutary medicine, and seeks above all the good of the faithful concerned. It is a positive means to attain the kingdom of God and to restore justice in the community of the faithful that are called to personal and communal holiness. Now, the Pope, in his apostolic constitution, introduces the new aspects of this revision. First of all, there is a very important principle that the Pope states very, very clearly, that one of the guidelines was that there had to be a continuity with the general guidelines of the canonical system according to the tradition of the Church that developed along the years. So this ablative absolute the Pope uses, servata continuitate, is very important, even to interpret aspects of the new law. It introduces changes that are important, but in the sense that, first of all, it creates new types of delicts in answer to the need, above all, to act in such a way as to restore justice and order broken by the delict. And we will be able to see what new delicts have been introduced by this apostolic constitution. From the technical point of view, the text has been improved, especially with regard to the fundamental principle of penal laws, that is the right of defense, which is explicitly recognized at a number of points, and the statute of limitations for both the criminal and the penal action has also been reviewed. And there has been also a more precise determination of penal sanctions, as required by penal legislation, because the principle of certainty and knowing exactly what the consequences of your actions are is a very important principle of penal legislation, whether civil or canonical. But also the review helps to provide judges and ordinaries with objective rules for deciding which penalty is more adequate to apply in a concrete case. There is a general rule of this revision, which is to reduce the canons where the application of penalties is left to the discretion of the authority, in order that servatis de jure servandis, that is, after having respected all the norms appropriate and adequate for the case, the unity of the Church is promoted, especially if the delicts are concerned that cause greatest harm and scandal in the community. The idea is not to have a monochrome uniformity, but to have communion and also a unified approach to aspects that are really harming the community. As I said, the Pope concludes by determining with his apostolic authority that this text is to be promulgated, published in Osservatore Romano. It enters into effect, as I said, on the 8th of December, the Feast of the Immaculate Conception, 2021, and on that day, the old version of Liber Sexus, Book 6 of the 1983 Code of Canon Law is abrogated, and this takes its place. There were comments which were offered when the new law was presented on the 1st of June 2021 in a press conference in the Vatican organized by the Pontifical Council for Legislative Texts, and the important introductions made by the President, Archbishop Filippo Iannone, and also by the Secretary, Bishop Juan Ignacio Arrieta Ochoa de Cincertru, are very, very valuable. I will take the important introduction made by Archbishop Filippo Iannone, actually repeated some of the main important aspects of the Apostolic Constitution, which I have already described. But Bishop Arrieta gave us some interesting statistics. According to Bishop Arrieta, 633 canons out of 89 were amended, 71%. 9 out of 89, that is 10%, were moved from one place to the other in Book 6, and some of these innovations are very important, and 17, that is 19%, remained unchanged. There are 3 guiding criteria. That is, first, a more adequate determination of the penal norms. The second principle is a concern for the protection of the community. In fact, in a number of canons, there is an insistence on the need for reparation of scandal and compensation for damages. The award of damages becomes something that we bishops need to take very, very seriously. We have a canon, Canon 128, which talks about the principle of indemnity when there is harm and when damages are produced, but even in the procedural laws concerning penal procedure, we also have allowance for the action for damages. There is also an interesting innovation when it comes to ways and means in which bishops need to correct and protect the community by preventing offenses, but also the introduction of the presumption of innocence. These are very important principles. We'll be able to review them when we go quickly through some new canons that are worthy of our attention. In fact, I would like to start by noticing a very important innovation in the very first canon of Book 6. And to Canon 1311, that states the Church has its own inherent right, jus nativum, to constrain with penal sanctions Christ's faithful who commit offences, there's a paragraph 2, which is, I think, very important. The one who is at the head of a church must safeguard and promote the good of the community itself and of each of Christ's faithful, through pastoral charity, example of life, advice, and exhortation, and if necessary, also through the imposition or declaration of penalties in accordance with the provisions of the law, which are always to be applied with canonical equity and having in mind the restoration of justice, the reform of the offender, and the repair of scandal. So this important new paragraph not only summarizes the 3 purposes of penal sanctions in church law towards the end, but also is an important exhortation to us bishops and other leaders in the church to lead by example, but also not to refrain from imposing or declaring penalties if necessary. And one aspect I would like to share with you, which I think is very important, is the insistence of Canon 13:16, which says diocesan bishops are to take care that as far as possible any penal laws are uniform within the same city or region. That is, people have a right to expect that the same laws apply throughout a region, throughout a country, throughout a city, and that our reaction is also a witness to communion and fraternal charity. Canon 1321 introduces a principle which was practically unwritten, but now is expressly stated in the code. It says, any person is considered innocent until the contrary is proved. So that we have an explicit reference to the principle of presumed innocent until proven guilty. And this is very important for the status of the accused before being convicted. There is a presumption of justice, and we need to take this into consideration when deciding what disciplinary action we need to take before the final verdict of a decision in a penal trial. This, however, is compatible and it is actually within the same canon where the law also keeps, because this is an old tradition canon law, the presumption that if there is an external violation of the law, then imputability is presumed. In fact, the law has not changed when it states in 1321 paragraph 3, where there has been an external violation, imputability is presumed unless it appears otherwise. When the new revised Book 6 comes to the classical list of factors or circumstances that exempt a perpetrator from a penalty, it insists, however, in paragraph 3 of Canon 1324, that in the circumstances that exempt a person from punishment, the offender is not bound by a late sententia penalty, but, and this is the novelty, but may have lesser penalties or penances imposed for the purpose of repentance or repair of scandal. Title 4 of Book 6 concerns penalties and other punishments, and chapter 1 of this title concerns censors. Now, in the new Canon 1331 reorganizes the old canon and explicitly states what constitutes excommunication. In fact, it says an excommunicated person is prohibited from celebrating the sacrifice of the Eucharist and the other sacraments, from receiving the sacraments, from administering sacramentals, and from celebrating the other ceremonies of liturgical worship, from taking an active part in the celebrations listed above, from exercising any ecclesiastical office, duties, ministries, or functions, from performing acts of governance. Now, a very important new law under this section of censors is that, according to 1335, paragraph 1, if the competent authority imposes or declares a censor in a judicial process or by an extrajudicial decree, it can also impose the expiatory penalties it considers necessary to restore justice or repair scandal. The title concerning chapter 2, expiatory penalties, has been reorganized, and we have these 4 types of expiatory penalties: orders, prohibitions, deprivations, and dismissal from the clerical state. This is a very important example of how the new Book 6 tries to make things more clear and more simple for us bishops. Interestingly enough, I would like to point out this, that in this reorganization there is an element of input from the Episcopal Conference, which is expressly requested and indicated by the Code. In fact, if we go to the text, the new text of Canon 1336, and we go under the first type of expiatory penalty, which is an order, it says an order is to reside in a certain place or territory. This is new. Number 2, to pay a fine or a sum of money for the Church's purposes, and it says in accordance with the guidelines established by the Episcopal Conference. So more work to do for the conference. And even when it comes to prohibitions, there is a list of 7 numbers under prohibitions. Interestingly enough, number 7 says a prohibition against wearing ecclesiastical or religious dress. Now, the question of whether one wears habit or ecclesiastical dress is now considered also included under a prohibition, under a penalty. And there is the second reference to the guidelines established by the Episcopal Conference when it comes to deprivations of ecclesiastical remuneration. And in fact, Canon 1336, paragraph 4, number 5 says, of course, deprivation of all ecclesiastical remuneration or part of it in accordance with guidelines established by the Episcopal Conference without prejudice to the provision of 1350, paragraph 1, which says that no penalty should make a person totally indigent and totally poor. Another important thing worthy of note comes from chapter 3 of this title 4, and chapter 3 deals with penal remedies and penances. Now, with the new reorganization, there are aspects that are new. In fact, 1339 paragraph 4 says, if on one or more occasions warnings or corrections have been made to someone to no effect, or if it is not possible to expect them to have any effect, the ordinary is to issue a penal precept in which he sets out exactly what is to be done or avoided. Then, of course, another thing is introduced, which is vigilance. We usually had admonition or warning, we had reprimand, and now we not only have a penal precept, but we also have vigilance. If the gravity, and that's paragraph 5 of 1339, if the gravity of the case so requires, and especially in a case where someone is in danger of relapsing into an offense, the ordinary is also to subject the offender over and above the penalties imposed according to the provisions of the law or declared by sentence or decree, to a measure of vigilance determined by means of a singular decree. This is a very important development. When it comes to Title 5 of Book 6, the application of penalties, we have a very important introduction in Canon 1342, which has a direct reflection on penal procedure. I mean, we're in a section, Book 6, which deals with penal sanctions. It determines the crimes, the delicts, and the penalties, and the way one applies them. And the question of penal procedure is under Book 7, which deals with procedure. But there are some interesting points that will certainly have an effect and are intended to have an effect in the way trials are celebrated or directed under the new law. In fact, 1342 reads now, whenever there are just reasons against the use of a judicial procedure, a penalty can be imposed or declared by means of an extrajudicial decree, observing Canon 1720, which comes from Book 7, especially if in what concerns the right of defense and the moral certainty in the mind of the one issuing the decree, in accordance with the provision of Canon 1608. Penal remedies and penances may in any case whatever be applied by decree. Now, in this canon, a very important canon, fundamental, that actually allows for penalties to be imposed by extrajudicial decree when the law allows that, there is a specific reference to the two main principles of procedure. That is that a procedure in penal cases needs to ensure the right of defense of the accused, but it also gives an important criterion for judgment, whether it's judicial, and that's 1608 for judicial cases, Canon 1608, and judicial extrajudicial, that is 1720, or the administrative penal process. And it requires in the judge or in the delegate or the authority deciding an administrative penal process that they have moral certainty in the mind. When it comes to the application of penalties that are at the discretion of the judge, the new Canon 1343 gives important criteria, which are new but very, very important. If a law or precept grants the judge the faculty to apply or not to apply a penalty, he is, without prejudice to the provisions of Canon 1326, paragraph 3, to determine the matter according to his own conscience and prudence, and in accordance with what the restoration of justice, the reform of the offender, and the repair of scandal require. In such cases, the judge may also, if appropriate, modify the penalty or in its place impose a penance. So this is another case where the Code introduces the reference to the three purposes of canonical sanctions, and also makes the point that in deciding whether to apply or not a penalty, the judge has to see the wider context, not only what the perpetrator is asking, but also the good of the community. We've also referred to the question of vigilance, which returns in a new paragraph 2 of 1346. Now, ordinarily, this is paragraph 1 of 1346, this is the principle. Ordinarily, there are as many penalties as there are offenses. The new number 2 says, nevertheless, whenever the offender has committed a number of offenses, and the sum of penalties which should be imposed seems excessive, it is left to the prudent decision of the judge to moderate the penalties in an equitable fashion and to place the offender under vigilance. So vigilance appears here as an important tool when the total sum of penalties needs to be mitigated. When it comes to Title VI, the remission of penalties and the prescription of actions, I would like to point out an important novelty, which is 1361, paragraph 4, which states, remission must not be granted until in the prudent judgment of the ordinary, the offender has repaired any harm caused. The offender may be urged to make such reparation or restitution by one of the penalties mentioned in Canon 1336 to 4, that is expiatory penance. The same applies also when the offender is granted remission of a censure. And this is a very important point, because remission is not to be separated from the need to repair scandal and to make restitution. Now, Canon 1362 concerns the statute of limitations, and this is a very important development. First of all, 1362 paragraph 1 gives the normal or the basic statute of limitations or prescription as 3 years. It obviously creates the following exceptions. First, offences reserved to the Congregation for the Doctrine of the Faith, which are subject to special norms, Sacramentorum Sanctitatis Tutela is the law which is in force at the moment. Then there are a number of offences that are prescribed after 7 years, whereas sexual abuse of minors, 1398, paragraph 1, is extinguished after 20 years. So we have 3 years, 7 years, and 20 years. But there is a new development which is very, very important, and I think really historical, because 1362, paragraph 3, introduces this mechanism whereby prescription, or the statute of limitations, is suspended as soon as penal procedure starts. But it is suspended for 3 years. Once the 3 years elapse, the statute of limitations starts to run again. So this is an indirect indication that penal procedures can't actually get too long or become a means of putting a person in limbo. When the offender has been summoned in accordance with Canon 1723, and this is in a judicial penal trial, or informed in the manner provided in Canon 1507, this is the summons, paragraph 2, of the presentation of the petition of accusation according to Canon 1721, prescription of the criminal action is suspended for 3 years. Once this period has expired, or the suspension has been interrupted through the cessation of the penal process, time runs once again and is added to the period of prescription which has already elapsed. The same suspension equally applies if, observing Canon 1720, number 1, the procedure is followed for imposing or declaring a penalty by way of an extrajudicial decree.
I guess that's the end of the first part. The second part, we'll watch it tomorrow morning. So, Archbishop is taking any other comments or no?